services on behalf of the employees and proceeded with arbitration instead. The employees filed suit claiming a violation of their Age Discrimination and Employment Act rights, and in essence the court held that the clause in the collective bargaining agreement that required union employees to arbitrate discrimination claims, including age claims, did not violate the employees' rights. The age discrimination law does not prohibit the arbitration of claims, and basically the court held that under the National Labor Relations Act, it couldn't nullify a clear or unmistakable contractual arbitration provision, meaning that if it's covered in the collective bargaining agreement, then the employees have no rights outside of the agreement. Now, this particular case caught the attention of the legislature, and we are now looking at the possible passage of the Arbitration Fairness Act of 2009. And I'll take a look at that, but it's really similar to the concept of the Lilly Ledbetter Fair Pay Act, which was a reaction to the Ledbetter case in 2007 where Ms. Ledbetter lost her bid for back wages based on having missed a statute of limitations, and the legislature took almost immediate action to what they call correct that inappropriate Supreme Court decision, and we'll talk a little bit more about that issue in just a few moments as well. The third case...
Excuse me, it's Xander. Am I on the right slide?
Yes, you are.
Okay, all right, just wanted to check. Thanks.
Sure. The third case that I wanted to highlight is the Gross versus FBL Financial Services case. And that particular one I highlight really just for the point that in a 5-4 decision, the Supreme Court indicated that the Age Discrimination and Employment Act does not permit an employee to establish age discrimination by showing that age was merely one of many motivating factors for the employer's decision-making process. This means that the so-called mixed motive analysis that we often see used in Title VII discrimination cases will not be applicable to cases under the ADEA. Now, like the 14 Penn Plaza case that I mentioned a few moments ago, this has caught the attention of the legislature, and we are looking at possible passage of an act called Protecting Older Workers Against Discrimination Act, i.e. POW. Okay, so those are two pieces of legislation that we're watching and may or may not pass in some permutation in 2010. The final Supreme Court case I wanted to mention is Crawford. That one, I don't even know why the Supreme Court took that case. It was a waste of their time. In essence, they reified the concept that you cannot retaliate against employees who cooperate in internal investigations under Title VII. In this particular case, the person didn't come forward voluntarily. She was called into an investigation and then disclosed the information. However, again, the Title VII non-retaliation protections applied to her as well. I wanted to also mention a Third Circuit case that the Third Circuit does encompass both New Jersey and Pennsylvania, and it's an important case. It's Houston versus Procter & Gamble Paper Products, and it deals with the question of who are management-level personnel for purposes of employer liability based on knowledge of harassment. In essence, this particular case really is important for the holding that an employer's knowledge, an employee's knowledge of harassment will not necessarily result in an employer's liability if the employee can be determined to be a non-managerial level. And it goes a little further to identify what that means. In essence, supervisors who have no authority to hire, fire, or change conditions of employment of other workers are not going to be found to be management-level personnel sufficient to impute liability to an employer where the employee happens to know about unlawful harassment under Title VII. This case I like mainly because it tells employers to have a good look, do a little self-internal audit as to what supervisors really do and whether they have the ability to have an impact on the terms and conditions of employment for lower-level employees. It's a very interesting aspect in terms of defending against any type of protected discrimination, harassment. It's not just sexual harassment anymore. It's everything. It's racial harassment, age harassment, and so forth. Now, let's talk a little bit about some of the statutory changes that occurred in 2009. This particular slide is simply an overview of the statutory changes that were effective in 2009 and some that occurred but will not or were not going to be effective until early 2010. You can see that there are quite a number of them, and I'm going to deal with each of them very briefly, time permitting here. Likewise, effective in 2009 was the Lilly-Ledbetter Fair Pay Act, 4 pro-labor executive orders having to do with government contractors, some ARRA changes, and the E-Verify rule. I'm going to start with the Americans with Disabilities Act Amendments Act of 2008, the ADAAA. This was a Bush-era law. It was effective January 1st of 2009, and ultimately it made many, many changes to the definitions and statutory interpretation of the law. It also had the impact of rejecting a number of Supreme Court holdings, and I'll point out that the EEOC published proposed regulations on September 23rd, 2009, and that public comment period ended on November 23rd, 2009. Just by way of reminder, the Americans with Disabilities Act applies to employers with 15 or more employees, prohibits discrimination against qualified individuals with disabilities, and is administered and enforced by the EEOC, and also pursuant to the Civil Rights Act of 1991, compensatory and punitive damages for intentional violations are available. The ADAAA does retain the ADA's basic definition of a disability. As you can see, it's the impairment that substantially limits one or more major life activities, having a record of such an impairment, or otherwise being regarded as having such an impairment. And in essence, we look at all of those prongs when we assess whether an ADA claim is valid from the employee's perspective or defensible from the employer's perspective. This is a piece of legislation that blatantly overturns 4 United States Supreme Court decisions that arose in the late part of 1999 and into 2002. The 4 cases are listed here, but in essence, Congress maintained that the Supreme Court had misconstrued the ADA and had therefore restricted its coverage within those cases. So when you look at Sutton, Murphy, and Albertsons, you'll see that the concept of mitigating measures was to be considered when determining whether an individual was disabled under the ADA. And because the Supreme Court assessed it that way, the impact was to exclude people from coverage who would be substantially limited in major life activity unless they had those mitigating measures, such as things that help them walk better, things that help them to actually perform the job for which they are qualified, even though they're an accommodation or they happen to be an instrument of some type. Those people are coping, and those people are actually as productive as someone who is not disabled. And so what the court was saying, mitigating measure does level the playing field for non-disabled individuals and disabled individuals, but the legislature was saying that mitigating measures are simply coping measures that disabled individuals use in order to try to climb up the hill to that level playing field. So they overruled those cases. Likewise with Toyota, Toyota had resulted in a higher standard for proving that an individual is sufficiently substantially limited in a major life activity to be disabled within the meaning of the ADA. And in essence, that meant that an individual who found ways to cope, found ways to work around his or her disability, found ways to mitigate, was not considered sufficiently substantially limited to be covered by the ADA. And again, the legislature decided to level the playing field by overturning the Toyota case. For the most part, we look at the concept of mitigating measures, and as you can see, they're simply measures that assist people to control or cope with impairments